My lady, I've reached what I've called the actual consideration point. This requires you to turn to the agreement for sale between PBL and MAR, which is at page 467 in Core Bundle 2, behind tab 6.
And the MS reference was?
467.
Thank you.
And it's between Project Blue and MAR, and one sees MAR is defined as the land, or identified as the land trustee. And on the following page, in the definition clause, one sees that there's a definition of tranche payment date, and then there's a definition of the transfer, meaning the transfer of the property to the land trustee, a property which is set out in the annex there too. And then if we pick it up, clause 4, which is the price. By clause 4 of the agreement, the price payable by MAR was payable in 6 tranches, which specified each in a US dollar amount. Some $757 million was payable on completion, and then a further $379 million odd was payable by additional tranches in 2009, 2010, 2011. And on top of that, there was an SDLT tranche, which was an amount going towards meeting PBL's SDLT liability, if it had an SDLT liability in relation to the MOD transfer. And then there was another $498 odd million, which might be paid as the additional payment tranche.
What was that for?
If one reads down, provided no additional payment tranche instalment shall be greater than the aggregate of 1, the rent due on the relevant payment date, 2, the amount of any fees and other payments due and payable by any finance counterparty to any finance party under the transaction document, 3, professional and or consultant costs incurred by or on behalf of Project Blue in a previous rental cost, which haven't been discharged, and 4, the initial transaction costs. So it's a number of supplemental payment costs relating to the overall transaction. But it fundamentally goes towards meeting some of the costs that would be of rental that would have to be met otherwise by PBL at a time when it didn't have any income stream. So the price for the property was calculated as a function of the expenditure which was likely to be incurred by PBL in holding the lease. But
so is that a very loose economic equivalent of pre-lending part of the interest payments in a commercial mortgage situation?
Well, these don't get pre-lent, of course. They're drawn down from time to time.
Yes, that's true. They're not advanced, but
no,
they
they're
cover.
Not advanced until they're called down.
But they cover.
And the advance, so not to speak, was made against a price notice delivered to the land trustee, which one can see at the top of the next page. In relation to any tranche, PBL will deliver the price notice to the land trustee in the case of the first tranche no later than 2 working days prior to the tranche payment date. And in the case of all other tranches, not later than 10 London time on 3 days prior to the proposed tranche payment date. And then the amount could come back down again if, in fact, the SDLT wasn't due on the MOD transfer. And then at clause 7, one finds completion, and it's clause 7.3, which, although it's defined as completion, are further conditions. PBL agrees the land trustee shall only be obliged in respect of the first tranche to complete and in respect of all tranches to make any payments pursuant to clause 4.1. If it has received a valid price notice in accordance with clause 4.1, if no default is continuing or would result from completion or the payment, if the repeating representations made to each finance counterparty on the relevant tranche payment date are true at that date in all material respects, if on the relevant tranche payment date neither a valid sale undertaking notice nor a valid purchase undertaking notice has been served, and except in relation to the first tranche to the extent the land trustee has received from an amount from the participants under clause 3.1.2 or from the investment agent pursuant to clause 3.1.4 of the investment agency agreement. So all of the later payments are conditional on the conditions set out in clause 7.3 being satisfied at the relevant time. And the Ijara was brought to an end on the 1st of March 2010, and the payments due after that date were never paid. And that's explained by paragraph 75 of the decision of the First Tribunal, which is at page 355 for your reference. And if one goes to page 847, Clifford Chancellor provided a rather indistinct schedule. I'm afraid it is rather indistinct schedule, which sets out the sums actually drawn down during the relevant period. And there are four column headings across the left-hand side: property, rentals, working capital, and total drawn. And the total drawn is then aggregated, and if one gets to the repaid amount at the bottom of that column, one sees the total amount which was drawn and then repaid, being a total sum of 1.673 billion odd US dollars. So 1.673,041,950 cents. So that was the total sum which was ever paid under the sale agreement.
Is that the equivalent of the 1.5 billion pounds that we've been talking about or not?
We started off with $2.47 billion because at the time that we were dealing with, the dollar UK exchange rate was something in the region of 197.
Right.
Happy day.
And it was, in fact, the translation rate is at paragraph 108 of my case at page 215, which it might be handy to look at. And one sees that the translation rate on the 31st of January 2008 was 1.9743 to the pound, which was why 2.5 billion became 1.25 billion of sterling. Now, the Commission has made their amendment to the land transaction return on the assumption that the taxpayer was £38.36 million, being 4% of £959 million, and they got that £959 million from the amount that was paid by PBL to the MOD. And then a couple of weeks before the hearing in front of the first-tier tribunal, they sought to amend their case to increase that to £50 million, being 4% of the 1.25 billion, which was a sum which was conditionally payable by MAR to PBL. But in fact, the total sterling equivalent to the amount drawn down by PBL was in fact 847 million. And that's because paragraph 9 of Schedule 4 to the Finance Act 2003 makes provision for the translation rate that you use when there is a drawdown or payments are made otherwise than at the effective date of the land transaction, and you just use the relevant exchange rate as at the effective date of the land transaction. So although there was a variation, a substantial variation during the relevant period between the US dollar rate and the sterling equivalent, one was always stuck with 1.9743 as being the appropriate translation figure. And that's why the sum total paid by MAR, actually paid by MAR to PBL, turned out to be 847 million in sterling terms. Which meant that if one were within section 75A and one were looking for the largest amount paid by anybody under the land transactions, one doesn't use the 847 million, one uses the 959 million paid by PBL to MOD, which would take one back to the amount on which Mr. Buttery assessed or amended the assessment, the self-assessment of PBL back in July 2011. And the debate between the parties is whether or not it was appropriate to have regard to the sum actually paid by MAR, or rather than the sum which might have been paid. And the scheme of the Act, and I developed this slightly in the beginning of the morning session today, is that provided one can identify a sum that may be paid, one starts off by assuming that it will be paid. But if at a later stage it transpires that a smaller sum has in fact been paid, then you substitute for the larger sum you brought in the beginning the actual and correct sum at a later stage. And the two provisions which achieve that between them are section 51 and section 80 of the FA 2003. And section 51 is at page 1064. And one sees that it deals with contingent consideration, uncertain consideration, and unascertainable consideration. And 51.1, where the whole or part of the charge of consideration is contingent, the amount or value of the consideration should be determined for the purpose of this part of this Act on the assumption that the outcome of the contingency will be such that the consideration is payable. So one makes an assumption in favour of the revenue to start with. But section 51 is, as section 51.4 makes clear, subject to section 80, which is the adjustment where the contingency ceases or the consideration is ascertained. And section 80 we saw this morning, it's at page 1083. And the relevant provisions are sub 1, sub 2, and sub 4. And we looked before at sub 2. If the effect of the new information is that the transaction becomes notifiable or more tax is payable, then you've got to make your return. And then sub 4, if the effect of the new information is that less tax is payable in respect of transaction than has already been paid, the purchaser may, within the period allowed for amendment of the land transaction return, amend the return accordingly. So it's an amendment of the return process. If the return can be amended, it should be amended to the right figure. And after the end of that period, he may, if the land transaction return is not so amended, make a claim to the Inland Revenue for repayment of the amount overpaid. And what it does, the section, is to require, it says, or permit reconsideration of how the part applies to the transaction. So it's a recalculation of the original consideration paid. That's what subsection 1 says. What they don't specifically make provision for is what happens if, subsequent to the time when a land transaction return is filed, the commissioners do what they do in this case, which is to open an inquiry into it, and then decide that it needs to be amended to substitute amount of chargeable consideration for the amount first thought of. And what happens if, in the meantime, facts have moved on and we now know what the actual consideration was as opposed to what the contingent consideration should be? Now, the process undertaken by Mr. Buttery was an amendment process. He was still amending the figures which were included in the return. And in my submission, when one's amending a return, whether one's the revenue or the taxpayer, when one's amending a return and one's got an obligation to amend a return, or one takes upon oneself to amend a return, what one has to do is to include the right figure rather than the wrong figure.
Put like that, yes. Does it all depend on the words given by or on behalf of in 75A5?
Well, even there, if one was looking at the word given, I mean, my learned friend's argument below is that given is itself part of the code, and you then got to dictate that by reference to Section 51, and Section 51 brings in the contingency.
Yeah.
But he was loath to allow the Section 80 to operate as well in order to adjust the contingency once he's brought the contingency in. We say, well, let's go through the whole process and get the figures right. And the amendment process in paragraph 23 of Schedule 10, which is at page 1182 of the bundle, is that the closure notice must either state in the opinion of the Inland Revenue that no amendment of the return is required, or make the amendments of the return required to give effect to their conclusions. Well,
So you're reading from which page, sorry?
that's paragraph 23 on page 1182.
Paragraph 23.
Yeah, 23.2.
Thank you very much.
And going back to paragraph 13, you'll recollect that the inquiry process, it relates to the question whether tax is chargeable or to the amount of tax so chargeable. So that's the exercise which is undertaken. And we say again that facts are to be preferred to prophecies. And the locus classicus for that is the decision of the House of Lords in the Bulfer case, which I've cited in my printed case, and which is also to be found at page 1578 in Authorities Bundle 3, tab 33. The relevant passages are in the speech of the Earl of Halsbury on page 1580 to 81, where in the context of an arbitration, admittedly an arbitration trying to work out how much had been lost by the relevant person, which was a miner which had been prevented from working its mine by a water operator. And what is said at the bottom of page 1580 is, the question is then the person who has to make the calculation what the compensation ought to have arrived at, which experience is now shown to be the correct amount. It is true he probably would not have been able to arrive at that sum accurately, but he ought to have contemplated upon such material as he had what would be the true sum. We now know what would have been the true sum, and the proposition broadly stated appears to be that because you could not arrive at the true sum when the notice was given, you should shut your eyes to the true sum now you do know it, because you could not have guessed it then. And similarly at page 1583 in the judgment of Lord Macnaghten, about two-thirds of the way down, he says, in order to enable him to come to a just and true conclusion, it is his duty, I think, to avail himself of all information to hand at the time of making his award which may be laid before him. Why should he listen to conjecture on a matter which has become an accomplished fact? Why should he guess when he can calculate? With the light before him, why should he shut his eyes and grope in the dark? So there we say, and that's been adopted by later decisions, and, for example, there is a tax authority I cite called Simpson & Jones, the judgment of Mr. Justice McGarry at tab 55, that I won't take you to, where the same sort of principle is applied. So we say that here one knows by the relevant time what the precise amount of the payment which had been made by MAR to PBL was. And since you're in the process of amending the return, that is the sum that you ought to bring in. Now, the tribunal decided that it shouldn't do that, but it gave no good reason in my submission for its decision. The reference is page 387 of the bundle. Paragraphs 259 to 266, and it's paragraph 266 which is the conclusion.
Sorry, can I ask you that reference?
It'll probably be page 388.
Thank you.
It's paragraph 266 is the conclusion. And it says, in our view, Section 80 does not operate to vary the consideration given ab initio. Once the period for amending and the SDLT return is closed, the effect of Section 80 is simply to create a right to repayment of tax on the making of a claim. We understand that no claim has been made by the appellant, to which the answer is, well, actually, the return hasn't been closed, because at the time we're dealing with, in July 2011, it was open for amendment by the revenue, and that's what they were doing.
But forgive me, it does all depend in that case. Well, at least that reasoning depends, doesn't it, on the meaning of, on the correct construction of the expression consideration given.
Yes.
For under 75A, 5, little a.
And my submission on that is twofold. First, it can't.
What do you give? What you've agreed to pay, or what you eventually pay?
Well, the simple Gordian sword to the Gordian knot is simply to say, well, the consideration which is given is the consideration which is eventually paid, and that is the correct amount. If somebody has a contingent sum which is payable under a scheme transaction, there is no reason for departing from the analysis elsewhere in the Act that a contingent sum is only to be taken into account until the time when it becomes clear that it is or is not payable. Once a contingency has fructified, at that stage you take into account the real amount of money, because that then is the amount of money that is sought by the statute.
You were at pains to point out to us yesterday that the scheme of 75A requires everybody to know how much is payable at the time when the last transaction happened.
Oh, indeed, because, of course, at that stage one's filing one's initial return. And if one had filed a section...
That's subject, you say, to 80?
Yes, exactly.
Yes. So,
Exactly.
so at the time of the matter was contingent, then the bigger sum
It would have been
was due.
1.25.
Once things worked themselves out, do you say, by analogy with Section 80, the revenue had to put in the correct sum?
Indeed, just so, my lord. And it is hardly surprising that the appellant had not made a claim to that regard at the relevant time, because, of course, it wasn't until the doors of the court that the argument for the £50 million ever arose. So at that stage, the figure that was being used by the revenue, that Mr. Buttery used himself, was what might call the right figure, which was the 38.36. It wasn't the 50 million. All that one is looking for here is to bring it back to the figure that Mr. Buttery used. The effect of the revenue's argument here is that when they reached the door of the court, the amount that Mr. Buttery had used was too small, and therefore the commissioners, the first-tier tribunal, ought to use a larger sum, which larger sum, it was apparent, had never been paid. And that, in my submission, is an absurdity which one really ought to balk at. And when one knows the true facts, it's inappropriate to try and rely on a provision which allows an adjustment to a return, to a closure notice which uses a too small figure, to substitute for it a larger figure which you know to be the wrong figure. And the provision on which my learned friends were relying for that purpose is to be found at page 413 in the bundle. It's paragraph 42.3 of Schedule 10. It says, if on appeal it appears to the tribunal the appellant is undercharged SDLT by self-assessment, or the appellant is undercharged by an assessment other than the self-assessment, the assessment shall be increased accordingly. Well, in what sense was the amount which had been used by Mr. Buttery an undercharge to SDLT when knowing the amount that had actually been paid by the Commission, by MAR to PBL, it arrived at a smaller figure than 959, and therefore 959, which was the figure which had been used by Mr. Buttery, was the right figure. They're relying on this to substitute the wrong figure for a correct figure on the basis that the correct figure was an undercharge. Now, that is the end of my submissions on that, and I'm well aware that I haven't reached my construction and human rights argument.
No.
I think in those circumstances, all I can do is rely on the submissions in my printed case, which I draw to your attention and invite you to adopt.
Well, I think that's very sensible, if I may say so, Mr. Thomas. Everybody is offered a certain amount of time. You divide it up between yourselves as seems
Absolutely.
fit to you, and you make such use as you see fit of the time that you have.
So,
and we try not to disrupt you too much.
indeed not. No. I absolutely. I'm perfectly.
If you're content with that.
I am content with that. Thank you so much.
Thank you very much, Mr. Yes, Sister Kenny.
My lady, I'll start by dealing with the points that my learned friend made yesterday afternoon, or the essence of them as I perceived them, in relation to section 71A of the Act. My learned friend, I think, sought to draw a timeline for events, including speculating at various points on what might have been within the revenue or maybe Parliament's mind in enacting the provisions that it did. In particular, I think my learned friend suggested that when first enacted, Section 72 of the Act, in other words, the sort of predecessor of Section 71A, would not have produced the result for which the revenue contend, because PBL could not at that time have been a vendor, that being something we now know from the Court of Appeal's decision in DV3. So, he says, when Parliament introduced Section 45(5)(a)(b), if the revenue is right, it made PBL a vendor and effectively opened the way for double relief through a combination of the subsale disregard under Section 45, subsection 3, and relief under Section 72. So, if I understood him correctly, your assumption should be that Parliament would not have intended to have done this. However, I say his analysis is wrong for the reasons that I shall now endeavour to explain. Now, when first enacted, the Finance Act 2003 referred to vendor on 52 occasions. I think it was Lord Hughes asked how many times it might have been referred to. It was referred to on 52 occasions. 26 of those occasions related to the provisions dealing with group relief, so half of them. And of the 52 occurrences of the word vendor, they appeared in 27 different provisions, of which 7 related to group relief and 7 related to chargeable consideration. And indeed, most of them can actually be seen in the materials that you have before you in tab 3 of the first authorities bundle, setting out the provisions for the relevant years with which we're dealing with. If you're wondering how I found that, I searched for the word vendor in the original Act of 2003, and actually if you search for vendor in your bundle, you'll also turn up most of the relevant references. Now, of the 27 provisions that include the definition of vendor, or include the word vendor, you've got the two definitional provisions, which are section 43.4, which defines vendor, and the index of definitions in section 122. And as I noted yesterday, the definition of vendor in section 43, subsection 4, is specifically made in relation to a land transaction. In other words, for the purposes of what we have called the SDLT world. So it doesn't, as I said yesterday, dictate the meaning of vendor if used in the description of a real-world vendor, even though real-world vendors will frequently also be SDLT world vendors. Now, of the remaining 25 provisions that use the word vendor, 21 of them do so specifically in the context of a land transaction. In other words, it's either specifically stated in the provision that it's dealing with a land transaction, or it's clear from the context that it's dealing with a land transaction.
Did you say 25?
Yeah, 21.
21.
21 out of the remaining 25.
21 out of the remaining 25.
Yes.
Yes. So that leaves 4 provisions where the word vendor is not used in the context or the explicit context of a land transaction, of which 2 are, of course, sections 72 and 73, each of which refer to the vendor on a purchase of a major interest in land as part of the alternative finance transaction. The other 2 are found in Schedule 9 to the Act, which deals with the right to buy and shared ownership leases, in other words, sales or leases of dwellings at a discount by relevant public bodies. And Schedule 9 refers to vendor twice in the context of a right to buy transaction, in other words, the transfer or grant of a lease of a dwelling at a discount. So that's the use of vendor in the Act as originally enacted. And as originally enacted, Section 45, subsection 3, tailpiece, ensured that completion or substantial performance of the original contract at the same time as the secondary contract was disregarded. And there was no qualification for that in relation to either Section 72 or 73. Now, the effect of Section 45, subsection 3, tailpiece, is that the transferor, under a subsale or similar transfer of rights, is not a vendor, although, of course, that was only known for certain following the Court of Appeal's decision in DV3 in July 2013. So the Court of Appeal's decision in DV3 was July 2013, and of course, up to that point, what had been argued was precisely how Section 45, subsection 3 operated in relation to the transactions, the partnership transactions you were looking at there. And the first tier and upper tribunals in DV3, the reasoning is not necessarily exactly the same, but anyway, it was uncertain up to July 2013. And the reason why a transferor was not a vendor, as defined in the SDLT world, was because in the SDLT world, the transferor is treated as never acquiring a chargeable interest, and therefore as never being in a position to transfer or dispose of a chargeable interest. So it can't be a vendor within the definition for the SDLT world, a vendor. So section 45, subsection 5A, is explicitly stated to apply to a land transaction within 45.3. In other words, the land transaction that occurs on the completion or substantial performance of the secondary contract. So it's clear that section 45, subsection 5A is operating in the SDLT world to treat there to be a vendor where otherwise in the SDLT world there wouldn't be a vendor. And it corrects for the fact, therefore, that in the SDLT world, on a transfer of rights, the transferor is not a vendor, or at least at the time at which subsection 5A was inserted, there was uncertainty as to whether it could be. Now, I say none of that, however, touches the meaning of vendor, where the context in which the word vendor is being used in the Act is in the real world and not the SDLT world, because 5A can only operate within the SDLT world. That's its function. And I say that subsection 5A doesn't provide a choice, but it provides an either-or. In other words, it doesn't have to be both people that tick the relevant box in the SDLT world. It can be either of them. Now, so that's the position as it stood in 2004 when subsection 5A was inserted. And as I say, it does absolutely nothing in relation to section 72 and section 73 because section 72 and 73 both use the word vendor in the context of real-world transactions. They're not talking about transactions in the SDLT world, as the vast majority of other references to vendor in the Act are doing. So we then, in terms of our timeline, go forward to 2005, when it was realized that the sale and onward sale or resale form of Islamic financing dealt with in section 73 allowed the combination of subsale relief for the first transaction on a purchase from a third party rather than a purchase from the borrower, and then exemption under section 73 subsection 3 for the onward sale to the borrower. In other words, where it was intended that the financial institution bought from a third party and would pay SDLT on that before selling on to the borrower, both limbs got the benefit of no SDLT, one by virtue of the subsale.
Onward sale to the lender, is it, or is it to the borrower?
Well, so you would subsell on to the borrower. The borrower would get the benefit of the exemption under subsection 3 of section 73.
Yes, I'm with you. Yes.
And the bank would get the benefit of the disregard for the subsale. So both limbs of the transaction would not bear SDLT, yes, even though there was obviously an intention in the Act that the first limb, the sale to the bank, should bear SDLT because it was buying from a third party rather than doing a repo type transaction with an existing owner, the existing borrower. So in 2005, Parliament qualified section 45.3 tailpiece so that SDLT remained payable on the purchase from a third party, and only the onward sale to the borrower was exempt. The ability, I say, to combine subsale relief with the exemption in section 73 subsection 3, I say only arises on the basis that you are interpreting subsection 1 in the real world, because, of course, in the SDLT world, on a subsale by a financial institution to the borrower, the financial institution is treated as never purchasing or selling any chargeable interest. So you have to read Section 73, subsection 1 in the real world, because if you were reading it in the SDLT world, you'd be recognizing that that the bank neither buys nor sells any chargeable interest. So when the vendor is used in that context, I say in both, what was originally Section 72, 71A and 73, it's being used in a context which refers to a real-world transaction which is recognized as such outside the SDLT world as being, in fact, the purchase and sale of a major interest in land, and there is no reason to apply the SDLT world definition of vendor to identify who it is you're referring to. So I say that, and this was our principal case, that Section 45 subsection 5A doesn't impinge upon Sections 72 and 73 because they're talking about vendor in a real-world context, not in the SDLT context, and subsection 5A only operates in the SDLT context. We then, in terms of our timeline, go on to 2011, I think it was, when it was realized that a purchase and lease transaction under what was then Section 71A, or indeed Section 72 as it originally was, could be combined with a subsale where that preceded the Islamic financing transaction. So the difference is that in Section 73, it was part of the transactional framework for the Islamic financing, the subsale from the third party through the bank to the ultimate borrower. Whereas, of course, in relation to Section 71A, the subsale precedes the Islamic financing transaction covered by that section. And accordingly, the tailpiece to subsection 3 of Section 45 was again amended to correct for that omission, but that was not stimulated by DV3, as I think my learned friend suggested yesterday, because DV3 at that stage hadn't reached the Court of Appeal. It may have been a case that was in course through the various tribunals, but actually it was a response to marketed avoidance schemes using Islamic finance. And we know that from a case called Frosch. I don't have to rely on anything in Frosch. It's a case before the first tier tribunal on a procedural point where the taxpayers were seeking the tribunal to direct a closure notice in relation to the avoidance transactions in question. And it just makes the point that this was dated back to August 2010, so one can see the relationship between a marketed avoidance scheme that was using Islamic finance around that time and the amendment that was then made in 2011 to deal with that omission from the Act that had been realised. I can obviously hand, if you would like copies of Frosch, I can hand them up. It's not in the authorities bundle. It's, if you want the reference for the case, it's 2016 UK FTT 558.
2016?
2016, yes. So and as I say, I'm not relying on it in terms of any authority as to what it says about the interpretation of the provisions with which you're concerned, my lord. I'm really just referring to it as providing the information that there was a marketed avoidance scheme around that time, which was what I
Back
say
in 2010.
stimulated the amendment. To
So it refers to that scheme in 2010.
yes.
I see, thank you.
We can hand that up if you would like a copy of that decision, but as I say, I don't rely on it for the interpretation. So I say that so although it is the revenue's case, of course, that Section 75A has provided an answer to this particular arrangement, whether one calls it avoidance or what, since December 2006, it is recognised that Section 75A is, as the first-tier tribunal described it, a blunderbuss, and while it negates the tax advantage, it is, in the context, taxing a consideration which, as I think the tribunals have certainly commented, it looks an inappropriate consideration. And the reason why the amendment was made in 2011 and why actually one should disapply Section 45, subsection 3 in this context was explained with admirable clarity by Judge Nolan in the upper tribunal. And Judge Nolan's explanation, we say, is correct, notwithstanding Lord Justice Lewison's criticism of it in the Court of Appeal. When you actually analyse what Judge Nolan says and compare it with what Lord Justice Lewison says, you can see, I submit, that Judge Nolan is, in this matter, actually correct. So Judge Nolan also explained with admirable clarity why the consideration charged under Section 75A is 1.25 billion, notwithstanding the fact that the price agreed to be paid to the Ministry of Defence was £959 million. I'll come to mention briefly my own friend's other submissions on consideration in due course. So, as I say, Parliament corrected the matter in 2011 so that the right person bore the right amount of tax on the right amount of consideration, having realised at that later stage the combination, the scope for combining Section 71A with subsale relief, subject to the outcome, of course, of this case on the application of Section 75A. And I say that is the correct timeline that one should take for analysing Section 71A and why the legislation changed as it did. And it's not the case, as my learned friend suggested, that throughout this period the real person, the real target of everything was really MAR, and that therefore the result of MAR being taxed in respect of 1.25 billion, even though the revenue had failed to amend its return as it should have done, I say that is wrong. So that's the point on Section 71A. Let me then turn to the other points that my learned friend made in relation to the vendor issue, as I called it, or section, sorry, the who is P issue, the Section 75A issue. Here, my points, I think, are reasonably brief. I just emphasise the fact that we adopt the reasoning of the first-tier tribunal and the Judge Nolan in the upper tribunal as to how you identify P. And for that, as I respectfully pointed you to yesterday, one needs to look at what the first-tier tribunal and the upper tribunal said by way of analysis, not merely their very brief one-paragraph summary of the introduction to the revenue submissions on the issue, so one needs to read the analysis. And that, I think, certainly in relation to the first tier tribunal, illustrates how the avoidance element, in other words, trying to identify what is the right amount of tax that should be paid in relation to the transaction, fits into the conditions of section 75A. So we don't test it by way of a sequential approach, but I was illustrating that even if one adopts a sequential approach, you arrive at the same conclusion. My learned friend this morning relied on the reasoning of the Court of Appeal, but I say the reasoning of the Court of Appeal must be wrong. And I say that, I say it for a number briefly, points. They say you stop at the first person who acquires the freehold and ask yourself the question there, and that you don't then move on to look at the lease that's derived from the freehold. But how can someone not be in the chain acquiring the freehold where you've eventually got a lease that is granted out of it? So it renders nugatory, for example, if one turns to section 75A, which is at page 1079 in the bundle, we can see that in subsection 3 in particular, it tells us that the acquisition by P of a lease deriving from a freehold owned or formerly owned by V. So section 75A 3A specifically recognises that the freehold may have moved away from V and be owned by someone else, and then a lease is derived from it. So if you're always going to work it on the basis of you stop at the first person who owns the freehold and don't go any further, you've immediately rendered OTOs the reference to formerly owned by V. And indeed, I think within the whole context of the provision, there is absolutely no reason why you would conclude that what you're looking at is the first person into whose hands the freehold comes from V. It's also fair to observe that I think for Justice Patton, who adopted this approach, did not consider the application, if MAR was to be P, of subsection 7A, and ask himself the question whether or not, when you were looking at MAR, you would conclude in any event that from MAR's perspective, the subsection 1C is not satisfied because MAR is entitled to relief under section 71A. My learned friend also made the point that under section 75A, subsection 2D, it says that a transaction which takes place after the acquisition by P of the chargeable interest can be taken into account. So my learned friend says, well, you've got to take into account the fact of leasing to PBL by MAR. You can't ignore that. That must be part of the scheme transactions. That is not correct. If you look at 3, what that tells you, look at subsection 2, what that tells you is that transaction includes a transaction which takes place after the acquisition by P. It doesn't tell you that it's a scheme transaction. And it's a scheme transaction if it's a transaction which is involved in connection with the disposal and acquisition. So when we're looking at MAR, we're looking at the disposal by MOD and the acquisition of the freehold by MAR. And as I said yesterday, if you're asking yourself, is the onward lease to PBL a transaction which is connected with that movement of the freehold from the MOD to MAR, I would say you could conclude that it's not, because the onward lease is not a transaction which is involved in, or certainly that is as I put it to you yesterday, and it's not answered absolutely by 2D, because 2D just tells you that it's a transaction. Things that can occur afterwards, for example, making payments or something like that, can be a transaction, but there's no necessary requirement that an onward lease by MAR to PBL is a transaction which is connected with the movement of the freehold from the MOD to MAR. If you're asking yourself the question, is MAR P, and you're effectively stopping at that point. But as I said yesterday, even if you have to conclude that the onward lease is a transaction connected with the acquisition of the freehold by MAR in this analysis, you'd still conclude that that's taken out by subsection 7A, because the only reason why MAR is not paying any SDLT is because of section 71A on that basis.
I understand the second bit of that, Mr. Gammy, but I'm not quite sure that I've got the right one, the first bit written down right. I've written, we say lease on to PBL by MAR is not involved in connection with the disposal and the acquisition.
Yeah,
Is that right?
the disposal or the
It
acquisition.
wouldn't have happened otherwise, would it? They're completely interdependent, these two transactions, aren't they?
No, but what you're testing here, as I say, this is not the argument on which we rely.
No, I appreciate that.
But if you're testing whether MAR is P on the basis either of the sequential basis that my learned friend has argued below, or the Court of Appeals approach of saying, well, you ask yourself who's the first person who gets it.
Yeah.
Stopping at that point, the onward lease to PBL is not a transaction which is connected with the transfer of the freehold from MOD to MAR.
This is your reading of what?
If you stop at that point.
Yes. It's your reading of 1B, in effect. A number of transactions are involved in connection with disposal and acquisition. And you say, well, if you stop at the acquisition, you don't have to say, well, the acquisition also was necessary to achieve the next phase, because you're looking in A at the disposal by V and the acquisition by P.
Yes.
That essentially, I think, is the argument.
That's essentially the argument indeed, my lord, yes.
Okay.
My learned friend demonstrated his knowledge of a rather complicated scheme involving groups in making his point that when it talks about a lease derived or chargeable interest derived from the freehold, to which I say, well, that's very interesting, and that may well be one of the transactions at which it's aimed, but it's absolutely plain that it's not the only thing that's caught. Again, it would render subsection 3A nugatory when it talks about the acquisition of a lease deriving from a freehold owned or formerly owned by V. But it's also observable that the fact that the Parliament has specifically taken out section 71A transactions is an indication that Parliament recognised that a 71A transaction which involves an acquisition and then an onward lease was the type of thing that would be covered or could be caught by subsection 1 of 75A. So it provided a specific exemption for that type of transaction under subsection 7A. So I say even if it's true that this was formulated with the complicated group relief scheme my learned friend outlined in mind, that doesn't tell you anything about the other circumstances in which, where a lease is derived from the freehold, the section can apply. So that is my answer on that. When you apply the section to PBL as P, I say that you can scratch your head, stand on your head, you can go and walk round the block or whatever. What you always come back to is the reason why there was no stamp duty land tax paid in respect to this transaction is the combination of the section 45.3 tailpiece disregard and the section 71A relief. And however long you think about it, you can't get away from that. And therefore, in relation to PBL, subsection 7A is not good enough because that only knocks out the 71A aspect of that tax saving. My learned friend then made various points about avoidance of tax and the various evidence that was before the tribunal on this. We've dealt with this to an extent in our written case, and I won't say a great deal more about it. As regards the 50 million tax on 1.25 billion consideration, I think my learned friend said, well, we didn't produce any evidence. Actually, we didn't need to produce any evidence because it was the basis of MAR's land transaction return in respect of which it claimed section 71A2 relief because it specified the consideration there. And in relation to the fact that about the absence of Sharia evidence that my learned friend, the points he made there, we considered their evidence and decided it wasn't good enough. And the first tier tribunal, having heard and considered all the evidence, reached the same conclusion. And it wasn't for us to improve upon their evidence, given that they'd been put to proof on particular aspects. So, but what I say is it's quite clear that they appreciated they were buying something on which they were going to claim to pay no SDLT, and that there was therefore a very large tax advantage requiring the DOTAS disclosure. And as regards the quotations from Willoughby as to whether or not the taxpayers borne the economic consequences that are expected, even my learned friend and PBL accept that some stamp duty land tax should have been paid. It's just that they say it should have been paid by MAR, not by them. And insofar as no stamp duty land tax was paid in respect of an acquisition of the Chelsea Barracks for some £959 million paid to the Ministry of Defence, nobody bore the consequences, economic consequences of the tax that even they accept should have been paid. In relation to the question as to whether or not there is an underlying avoidance purpose, Parliament has deliberately chosen not to attach anti-avoidance language, so express the need for some purpose, intent, motive related to avoidance, presumably for the very clear reason that they don't think it's they're describing transactions on which they think a certain amount of SDLT should be paid, and they're not going to get into arguments or expect the revenue to get into arguments about how it happened that no tax was paid for a transaction which can be described and brought within section 75A as one on which STLT should have been paid. It's not part of the revenue's case that it has a discretion as to who it chooses to tax as P under Section 75A. It's a case of what is the correct construction of that provision. Of course, Parliament can confer discretion on the revenue if it chooses to do so. We say it hasn't chosen to do so in this case. It has merely provided under legislation a provision which may not always be easy to apply to particular circumstances, but it's to be applied in the correct way to those circumstances, and we say in this case it's clear how it should apply.
But the revenue does claim a discretion not to apply 75A at all.
Well,
If that
well,
notice...
my learned friend drew attention to that, and he said, well, that the revenue wouldn't, and what the bit said, what the extract he referred to said, was that if the revenue concluded it has been correctly taxed, then they won't try and undo that or apply something different by reference to Section 75A. I mean, you can read those words in a whole variety of ways, but of course, it's not part of the revenue are not saying that if we can think of some other way of reanalyzing the transactions, we'll always be doing that or something like that. They're looking at whether or not the transaction has been correctly taxed. Of course, we're looking here at a transaction that wasn't taxed at all.
No, but I think if I remember, Mr. Thomas gave an example of a transaction which was innocuous, as it were, and 75A could be invoked.
Well, he did, my lord, and we wouldn't necessarily agree with the example he gave, because the question would be, in exactly the same way as I've mentioned a few, as whether or not the relevant transactions were effectively connected. And indeed, the first-tier tribunal, in analysing this, recognised that when you're looking at the three conditions in subsection 1, what you're trying to do is identify where there is a loss of tax, if I can put it in those terms. In other words, where the combination of transactions has led to an amount of tax being paid that is less than what you'd expect in a straightforward transaction. Now, in the sort of case that my learned friend outlined, I think it's fair to say that I think it was a sort of subsale that was with A, B, and C in it.
Yes.
If C comes along as an entirely separate matter, there'd be the question as to whether or not, within the framework of particularly condition 1, subsection 1B, whether the transactions were effectively connected in the right way. But as I say, the first-tier tribunal deals with this in its analysis and recognises that in giving a purposive construction to subsection 1, you've got to be able to look at what has happened and analyse whether or not there has been, as I've put it, an amount of tax lost when you look at it in that, through that mindset. And indeed, Judge Nolan applies similar analysis in his decision. And I would say that is a reflection by the tribunal of what the revenue were trying to articulate in their guidance. They were saying if you're looking at the transactions that have occurred and it looks as if they've been taxed in the right way, then we're not going to go in and try and reanalyze all these things on the basis that you could have done something different and it might have attracted some more tax. Now, I appreciate that it's very difficult to articulate in general terms something that is of general application, because what you're always trying to do is to apply the statutory language to a particular set of circumstances. And in that sense, we have to look at the circumstances we have before us.
Yes.
To see whether or not it meets the requirements of subsection 1 of section 75A, and I say it does.
Thank you.
And Mr. Gammy, can I just ask this? You couldn't you have I can't put a concrete one on paper straight away, a series of transactions, a number of transactions, which would admit of different persons being identified as P, depending where you stop the clock, so that you would have, if you like, a big scheme with, say, 10 transactions in it, but you could identify subsection 1 as applying to the first 5 transactions. Now, the Court of Appeal said a variant of, once you find one scheme, you stop the clock, because you look to the first person to get the original interest being transferred. But do you say that where subsection 1 could be satisfied in 2 different ways in relation to a complex scheme, you always look at the last one, or how do you make a choice in that situation?
Well, you certainly, so in a complex scheme where you've got lots of stages to it, it may well be that in deciding how the section should apply, you've got to think, I mean, as we've done in this case, is it right, is MAR the right person or is PBL the right person? In our case, I say the answer to that question becomes apparent when you do that exercise.
Yes, I understand.
You can see it, and you can tell from just standing back and looking at the transaction that it's PBL that makes the tax saving. In a far more complex transaction, maybe the sort of group relief sort of scheme that my learned friend was outlining, when I say it may be more difficult, I mean, as I say, it's very difficult to articulate a general principle in relation to an unknown set of facts. But I suppose if you concluded that, at stage 4, there was clearly an application that it could be applied, then you might well conclude that that is the right person, because that's once you've got identified that stage, it's sort of undone whatever is the tax saving. But supposing your transaction is such that at stage 5 you find that instead of 50 being taxed, 75 is being taxed, but by the time you get to stage 10 you find that 100 is being taxed rather than 50, but all of these things have to be framed within a series of transactions, so the transaction scheme, where you can say that they are connected in the relevant way.
Maybe you start with B then and work out what all the connected transactions are in connection with the disposal and acquisition. And when you've identified them all, you look at the beginning to find who V is and at the end to find who P is, providing the other conditions are satisfied. Is that
yes, right? Maybe. I mean, it may be, it may be that you apply the section twice, for example.
Well, I was wondering about
So you might find that you apply it at stage 5, but then it can be applied again at stage 10, because as between stage 5 and stage 10, you can identify another tax saving. As I say, I'm loath to be prescriptive about these things, because it is a section which has to be seen and applied and interpreted within the context of the set of transactions you're looking at. In that sense, I think it's difficult to articulate absolutely general principles. No doubt if it had been if it had been possible to articulate it in a somewhat different way, maybe the Parliamentary Council would have chosen to do so. Some, of course, in some jurisdictions, other Commonwealth jurisdictions, for example, like New Zealand or Australia, they've had general anti-avoidance rules, which effectively just allows the revenue to stand back and say, well, we're going to rewrite exactly what you did and tell you what the tax bill is going to be. And of course, there's a lot of judicial authority on whether or not that is a satisfactory or an operative provision, which I won't go into. But there are a variety of ways in which governments and parliamentary draftsmen have tried to deal with these sorts of things. So that, I think, is probably most of my points in relation to section 75A. In relation to consideration, just dealing with that point under section 75A, we rely on the fact that section 75A, subsection 5, talks in terms of consideration given, which within the framework of the Act, and looking at the time at which the effective transaction, so the effective date of the transaction is treated as taking place, means that you look at the contractual consideration that's given and you don't take account of the conditionality or contingencies that attach to it. It is open to the taxpayer to make a claim to adjust the matter after the event. And that is the framework within which the tax is charged and adjusted in relation to subsequent transactions.
So does Section 80 apply or not? Or does it not apply because there aren't any contingencies, or is there some other reason?
Well, if you've concluded that the original transaction involved conditional or contingent consideration, then you go to 80. Make a claim under Section 80.
In this kind of situation, are we into Section 80 or not, according to you?
Well, I think the Revenue's view has been that it's open to the taxpayer to make a claim under Section 80, and then that will be dealt with. But that's the framework within which the Act determines the consideration at the effective date of the transaction and then adjusts at a later stage.
So we construe subsection 5 without reference to what might very well have happened, which is movements in the exchange rate after the date of the contract.
Well, indeed, my lady, because what you're doing is you're identifying a notional land transaction which takes place at the specified time, and in respect of which the consideration given has to be determined at that time.
And that means Section 80 doesn't apply.
Well, not at that point in time. I'm sorry, I may have misunderstood.
No, it's almost certainly my fault, Mr. Gavin.
It doesn't apply when you're actually working out what is the tax charge by reference to the notional land transaction.
Yes.
Because that occurs at the effective date. The returns should be made and the consideration is determined then.
Got that. I'm
not saying that you can't then make a claim under Section 80 if you can demonstrate that the amount has changed. If you did happen to make a Section 75A land transaction return for a notional disposal, and I quite accept what Lord Briggs says, that maybe this is an unusual situation.
Well, it's a bit weird, isn't it?
It is a bit.
If one looks at what really happened, the actual amount paid was less than the consideration paid in the first place. So the amount to which you would be entitled would actually be the price paid by PBL Limited to the MOD. Because that's the largest sum payable, but that's rather hard to fit into any kind of Section 80 reclaim situation, isn't it?
The largest sum payable is by MAR to PBL.
Yes.
Your system.
So the notional land transaction has when I say a deemed consideration, you're told what the consideration is under Section 75A, which is the largest amount given, but I mean that consideration paid by MAR under its contract was to an extent contingent or conditional, and then a claim could be made when it turned out that actually
there's apparently a provision in the schedule somewhere which prevents you adjusting it for every change in the exchange rate, which one can perhaps imagine would be very tricky, but the point that's being made, I think, is not simply that there's a change in the exchange rate, but in the end, the drawdown was considerably less than the 1.5 billion that it might have been.
No, I understand my learned friend's principal point, not to relate to the exchange rate as such, save to the extent that when the amount actually drawn down would reflect, presumably, what the exchange rate was at the time it was drawn down, but that as matters turned out, less was drawn down than the amount of consideration specified for the transaction.
Now, are you saying that they could even now seek to moderate the sum that is actually has got to be paid to you if you're right, or not.
Well, my lord, they can do so by making a claim under Section 80.
And we can't deal with it at this stage?
The claim is, insofar as it's made, is not before this, is not a part of the case here. The question is, what was their liability under Section 75A at the time of the transaction?
Right.
And the issue of a claim for an adjustment to that would be a matter for separate determination.
But yes, clearly we're not having to decide that, but the mechanism which you're presenting to us, as I understand it, is under 75A5, the chargeable consideration being on the notional transaction is the largest amount given by one person. In that case, it's MAR to PBL.
Mm-hmm. Yeah.
You say at that stage you ignore the conditionality because you're looking at one point in time, namely the moment of the notional transaction. But you're saying that doesn't render irrelevant the conditionality of that consideration. So prima facie, the taxpayer may have a claim for the difference between the 1.25 and the actual consideration he paid as the contingencies worked out.
Yeah. So if you win on everything else, whatever is said is subject to that possibility. Yes?
Indeed, my lord.
That's what I was trying to clarify. Yeah.
In other words, the contingency built into the largest consideration paid for part of the formula infects the notional consideration, in the sense that if that never happens, you can have another go at the notional consideration.
Well, yes, as in for a real transaction rather than a notional one, if you've got contingencies,
Yes.
you can deal with it. Yes. So that, I think, Lord, brings me to the question of the fact as to whether or not it was the right or the wrong return.
Can I just check one thing? If, therefore, the contingencies upon which the highest consideration was calculated didn't occur, to an extent that that fell below the consideration payable somewhere else in the scheme, then that one would take over. In other words, there'd be a floor below which you couldn't reduce the payment,
yes.
the tax.
Yes. So your point being that the floor would be the amount received by the Ministry of Defence.
Yes, in this case. Yeah.
Yes.
Because they actually got that, didn't they?
Yeah.
Yes.
Nothing contingent about that.
That's sitting in.
So, in relation to the wrong return point, my learned friend said a number of points which I think as we would say, the fact that the closure notice didn't actually express a conclusion but didn't give any reasons was a reflection of the fact that the correspondence had discussed extensively the parties' bases for claiming what they did. And as the appeal notice indicates, there was actually no misunderstanding on the part of PBL as to the basis upon which the closure notice had been made. And indeed, it was the revenues case before the first tier tribunal that actually PBL should not have been entitled to change its, to amend its grounds of appeal to allow this point to be taken, and that is dealt with in our written case at, I think, Appendix 5, which is on MS 145. Oh no, that's the question of whether or not the revenue could amend its case to claim 50 million. It's Appendix 6 at 146. And I say, for the reasons that we set out there, this point should not have been allowed to be taken by my learned friend and PBL, and the first tier tribunal reached the wrong decision. Slightly odd. So the revenue has an appeal against this point from the first tier tribunal, but it was not actually dealt with by the upper tribunal because it decided on the same basis as the first tier tribunal that the PBL's appeal on this basis failed. And it wasn't dealt with by the Court of Appeal. But insofar as it is a point on which the revenue has appealed against the first tier tribunal's decision, we say that they should not have been entitled to take the point, and I will rest on what I say about this in Appendix 6. But even if they're allowed to take the point, we then deal at Appendix 7 with the amendment of the existing return. Of course, what we're looking at, as Lord Briggs, I think, pointed out, is it's a land transaction return that relates to something that is not a land transaction, because, of course, it's disregarded for the purposes of the Act. And what the revenue has effectively done, for the reasons, as we explain in Appendix 7, it has treated that as a return in respect of the notional transaction disposing of the freehold from the Ministry of Defence to PBL under Section 75A. And we say that that is something not only that was accepted by PBL, was not taken issue with in its notice of appeal, which we say is one reason why it shouldn't be allowed to raise the point at the late stage that it did, but is also illustrative, I say, of what was the revenue were entitled to do to ensure that the tax that was claimed by the revenue under Section 75A was dealt with through a return that reflected that actual transaction. As I say, that is dealt with in Appendix 7, in particular noting that what was amended was a return that identified the correct vendor, the correct purchaser, the description of the transaction being the estate or interest that was transferred, and the correct effective date for the transaction. We say that the revenue was entitled to treat that as a Section 75A land transaction return, which is amended in the appropriate way. My learned friend referred to writing a letter, or the need to write a letter to Birmingham based on the sort of general guidance that the revenue had issued. I think we would question whether that actually was a prescribed way of dealing with it within the regulation, but leaving that aside, the revenue were entitled to treat what was submitted to it in connection with the transactions as being the relevant return, even if it was not actually in the form of a letter written to Birmingham, as the guidance had suggested people might like to do if they wanted to make a Section 75A return. I think that's probably all I need to say about that.
Could you remind me, where is the provision again which empowers returns to be amended? It was given to us in discussion. I just can't find in my notes a reference to the page number.
It was, I think, in one of the additional pages.
Yes, that's...
Yes.
So it would be 1180A or something.
1180A possibly?
Yes. So 1180A was the inquiry into the return.
Yes, it's paragraph 13.
13
Yes.
An
of-
inquiry extends to anything contained in the return or required to be contained in the return. Are you relying on those latter words then? Because the return certainly wasn't a notional transaction return.
Well, it was a land have this oddity that
It was a return of a non-land transaction.
It was a
but it claimed internally by reference to that exemption number, a 45.3 disregard.
Yes, so a disregard.
Well, I haven't seen where that list of numbers is, but I think I'm told that's agreed.
Yes,
Is it 28? I can't remember.
Number 28,
28,
yes.
first
number
of the word
28,
45.
which I think is other,
Yes.
if I remember correctly.
Yes.
But they were submitting that return in respect of a transaction which fitted exactly the description of the notional return, in the sense of being recording in that return a transfer from MOD as purchaser to PBL as MOD as vendor to PBL as purchaser of the freehold interest. So it described, as the tribunals below concluded, it described exactly the transaction which the revenue were seeking to tax through Section 75A. They submitted it on the basis that this was just reflective of a non-land transaction, for which they put in 28. We effectively amended it by treating it as a Section 75A return, which of course they were obliged to make because it was a land transaction. And insofar as necessary, it was either an inquiry extending to what was contained in the return, which of course was included, I suppose, the 28 claim, but the paragraph 13 also covers, of course, required to be contained in the return. Yeah. So we were putting into the return what we said was required to be there to tax the transaction that we said this reflected.
Is it say in the absence of any letter from Birmingham or other notification other than the DOTAS? Is that what made it required to be there?
So they put in a DOTAS
Yes.
form. They didn't write to Birmingham. I don't.
No.
They didn't write to Birmingham. But supposing the revenue say, well, the way in which you should do this is to as they do, here, write to Birmingham, and the taxpayer actually writes to Coventry, and the revenue say, well, all right, then we'll treat this as being okay, and we'll deal with this accordingly. Can the taxpayer then turn around and say, well, actually, we wrote to Coventry, not to Birmingham, so you can't really
but that's quite different, isn't it? That's trying to give notice that there might be a Section 75A situation, but giving it to the wrong office. What's happened here is that no one has attempted to give notice, at least not subjectively attempted to give notice of anything to do with 75A at all. You've treated it as such because you say there is an obligation to notify that. Is it still, just before we get into that, is it still the position that liability under 75A involves an obligation on the taxpayer to spot that Section 75A might be in question and to put in a return about it?
Well, technically it is, yes.
Okay,
that's what...
The emphasis might be on the word technically, I suspect.
Well,
How often does the revenue receive 75A returns from taxpayers?
My Lord, I'm not sure whether they publish or keep statistics of these things, but I quite accept what Lord Briggs pointed out, that it would be quite remarkable if people did formally put in a Section 75A return,
quite.
Although, sometimes you come across these strange cases.
You'd have to have your tongue deeply buried in your cheek to treat this return as being a Section 75 return.
Well, but as I say, it wasn't a land transaction return in respect of a land transaction.
Oh, I accept it was another very odd bird as well.
Yes.
But the fact that bird A is an odd bird
the
doesn't automatically lead you to the conclusion it's really describing another odd bird called bird B.
Yeah. But it's certainly 75A is a notifiable transaction under Section 76. And of course, if no return is made, then the current statute allows the revenue to raise an assessment within 20 years. So I won't say one way or another done, because we don't rely on our ability to raise an assessment after 20 years. We say we're entitled. If you receive this material from the taxpayer, we say you're entitled in these sorts of circumstances to treat it in the way that we did. It wasn't that we did anything that was unknown or unexpected to the taxpayer. And he can hardly say, as I said in his notice of appeal, he knew exactly what it was that the revenue were asserting and why it was they were amending the return as they did. In other words, treating it as a Section 75A return, which described a transaction precisely that was the notional transaction, and to the extent that it didn't actually contain the material in the return, we were entitled to treat it as amendable by reference to what it should have contained.
Yes. So are you construing 13.1 as where it refers to anything contained in the return to include investigating the transaction itself and its consequences? Is that really what it comes to?
Well, I think that certainly is an element of it, my lord, because, as I say, what was returned described precisely the transaction that then the revenue amended the return to tax, even though, I mean, if you like, you could say that what was wrong with the return was that it put 28 in the other reliefs box. We struck that out and substituted the tax.
I mean, clearly paragraph 13 must be imposing limits on the scope of the revenues inquiry for obvious reasons.
Yes.
In response to a return. But is it the revenue's position that you don't have to look at what necessarily is being claimed in the return, what relief is being claimed, or what is being declared as the tax due? You can look at the transaction itself and see what is the proper tax due on it. Does this allow you to go that far?
Well, I certainly think it allows you to look at the transaction that is being described and in respect of which the question arises as to how it should be taxed. I mean, if I could put it slightly differently, I mean, are we saying that the taxpayer is able to submit a return, as it did in this case, and say to the revenue, well, here's a return in respect of these transactions that took place, but you can only look at it as a return in respect of the disregard disregard. You can't look at it as being taxable under the Act on some other basis. I mean,
it's another way to look at it is this is all the real governing words are in little a, aren't they? It must be anything contained in the return or required to be contained in the return. That relates to the question whether tax is chargeable in respect of the transaction. Yeah. Now, if the transaction is one of a series of transactions in relation to which, under Section 75A, it is not individually taxable, but a notional transaction is erected on top for the purpose of charging the whole shebang to tax, then do you say you might slip in under A?
Well, I think in this context, what you have to bear in mind as well is that Section 75A itself tells you that all the other transactions are to be ignored.
Well, they're to be ignored in the sense of calculating the tax, but they're not to be ignored in deciding whether you can have a notional transaction.
So I was just going to look up the precise language.
Well, but they have to be there in order for Section 75A to apply at all, don't they?
Well, they're there certainly in terms of being able to make the comparison between, well, for two reasons, I suppose, to make the comparison condition C, in other words, whether or not more or less SDLT, but also to calculate the consideration.
But there has to be a series of transactions.
Yes, but
which includes this one, I think, on your case.
But what we're told is that I wanted to look up the actual words. So it's section 75A, subsection 4A. Any of the scheme transactions, which is a land transaction, shall be disregarded for the purposes of this part. Of course, it's true to say that PBL is the purchaser in both cases. I mean, that's part of the description of the transaction in the return. So it's PBL is the purchaser in both the case of is being treated in the return as being the purchaser, whether you're talking about a return made by reference to a contract for which relief is claimed as other, or whether you're treating it as the purchaser under the notional land transaction.
Yes, so 13.1a does impose constraints, but you say the constraints, tax chargeable in respect of the transaction, is broad enough to cover the tax on the notional consideration, which arises as a result of, among others, this particular transaction.
Yes.
I think that's really what it comes to.
I think, yes, my lord. Yes,
Yeah.
that's right.
Okay, thank you.
My lady, I think that probably completes all the points I wanted to make in reply. I had said at the beginning that my learned friend, Ms. McCarthy, would deal with the human rights points. As my learned friend has sort of rested on what he said in his written case, I'm not quite sure whether you might want to deal with human rights from our side in exactly the same way, but maybe I should at least let my learned friend stand up and see if she wants to say anything.
Absolutely, she should be allowed to stand up. Thank you very much.
Thank you.
My lady, I'm most grateful. I intend to keep my submissions very brief and take our written case as read. For your note, your ladyship's note, it's Appendix 10, MS 156 is the reference. There are 5 propositions that I would make in response. And if I can set these out, then I will deal with some points underneath each very briefly. First, PBL has the burden of proving discriminatory treatment. Second, PBL has failed to prove discriminatory treatment. Third, if we're wrong about that and there is discriminatory treatment, it's objectively justified and proportionate, so there's no infringement. 4, if there is an infringement, then no Section 3 of the Human Rights Act compliant interpretation is possible. But 5...
Given that we've spent nearly 2 days arguing about the interpretation of the relevant provisions.
But 5, if one is possible, then all it is the March 2011 amendment that was made to the tailpiece of 45.3, which was to insert reference to Section 71A. And the 2 points that I want to emphasise at that point, if that is so, then Project Blue is charged to SDLT on 959 million on its real-world acquisition from the MOD, and the important consequence of that is if that is so, the wrong return point falls away, because then I think it's agreed that that is exactly what that return that was amended was. A few short points on Project Blue having the burden of proof. Project Blue is wrong to argue that the ordinary position is abandoned purely because HMRC is seeking to increase the assessment. The first tier was right for the reasons it gave, and that's at paragraph 271 of its decision, MS 388. Ultimately, Parliament is intended to legislate in a Human Rights Act compliant fashion. So if we get to 50 million of SDLT on normal purposive construction, then Article 14 is prayed in aid of as a defence, and Project Blue is in exactly the same position at that point as any other complainant would be. Taking this one step further, assume for the moment that HMRC wins here, tax of 50 million is levied on Project Blue. What is Project Blue's recourse if it doesn't like that answer? That's to go to the European Court of Human Rights. At that stage, the ECHR will be requiring Project Blue to prove its case in the ordinary way, and it wouldn't be disrupted just by reference to the assessment mechanics. Moving on to my second point, if that is right and Project Blue has the burden to prove discriminatory treatment, it has failed to discharge that burden here. First of all, when one looks at the general body of taxpayers, it is striking that there are no examples whatsoever of any other taxpayer that has found itself in the same situation as Project Blue was after the first-tier tribunal hearing, or, following the Court of Appeal's judgment, any other provider of Islamic finance that has found itself in MAR's unenviable position. So far as we know it, there are no other taxpayers whatsoever who have had any sort of disproportionate effect at all. That's not surprising, bearing in mind that the reason the £50 million situation has arisen here is as a result of the unusual features combining the subcell with the Ijara financing and borrowing more than the value of the property. And Mr. Latif, in his witness statement, confirmed both of those as being unusual to typical Ijara. Can Project Blue say, well, we know there are no others, but we, in fact, have suffered discriminatory treatment on the grounds of religion for the reasons that Mr. Gami has said in his opening and also in his reply? No, because ultimately, the first tier held that Project Blue had not adduced sufficient evidence in order to prove that it was not motivated in its choice of transaction by tax avoidance. That being so, we say that the one thing that Project Blue hasn't shown is differential treatment on the basis of religion, and the first tier was entitled to reach that conclusion. Strikingly, without the need to turn it up, but just for your ladyship's note, first tier decision, paragraph 234, MS 382, one of the observations the first tier made is it seems to us that the appellant has refrained from putting forward evidence of all the factors that may have been taken into account in the decision how best to finance and how to structure the financing of the acquisition of the property. So the first tier's impression was Project Blue did not put forward all the evidence. That being so, we say that at this stage it is impossible for Project Blue to overturn that decision on any sort of Edwards and Bairstow formulation. Moving on to my third area, if there's a difference of treatment, then it's objectively justified and proportionate. A few short points on this. My learned friend's complaint is directed at the breadth, essentially the breadth of 75A, and in particular, the fact that the consideration is fixed at 1.25 billion by reference to 75A, 5A, but also the constraints on what is defined an incidental transaction by reference to section 75B. We say ultimately the objective justification is this. Those provisions are deliberately broadly drafted in terms of section 75A and more tightly constrained in terms of section 75B so as to ensure overall that no transactions, if I could say, where an inappropriate amount of tax has been paid then slips through the net. Question. Is it a problem, if I can phrase it like that, if from time to time, one, and this is one transaction since this SDLT was first introduced, gives you a result that on its face looks too large, we say answer no, bearing in mind the overriding objective of 75A and why it was introduced. Answer especially no when one takes account of sections 75C, 11 and 12, which is the broad safeguard for the Treasury to, via regulations, disapply section 75A in certain circumstances. And we would say that that would extend to disapplying parts of section 75A. So here, the relevant part would be 75A, subsection 5A, if that is what is causing the problem in a case such as this. The point, therefore, is that as a whole, the provisions are proportionate precisely because there is this powerful safeguard built in. That would lead me on to my fourth proposition. If I'm wrong about all of that, is a convention-compliant interpretation possible? Specifically, is it the one that Project Blue identifies? We say no for three reasons. My learned friend complains in particular that the legislation expressly provides that a subsale to a third person cannot be treated as an incidental transaction. That is one of the reasons that his clients would end up in the problem that they face if we're right and taxes 50 million on them. But that being so, we say that that is something that this court cannot simply seek to disapply and put a line through. We would also point to section 75A sub 7. Parliament has clearly sought to disapply at 75A, where subsection 1C is satisfied only, emphasis on the word only, by reason of section 71A to 73. Parliament, therefore, has prescribed that only where alternative finance is the cause can there be a disapplication. So there is no room in the legislation to disapply 75A where there's a combination of factors, so here 45 and 71A. And the last factor that I would point to say there's no convention-compliant reading is, again, the Treasury safeguard at section 75C, 11 and 12. We would say that the Treasury is best placed, given that it will have a view of, or certainly access to, the full range of transactions that are being carried out by the full variety of taxpayers.
Where do we find that?
I'm sorry,
Where do we find 75C?
75C is MS, I'm sorry, I had it a moment ago. 75C MS 1080. (75C 1080) and its subparagraphs 11 and 12.
Is this a general power, or could it be used in a specific case?
So, my lady, we would interpret this as a general power, but the Treasury has the ability to closely define the circumstances in which it would apply. So that can be tailored as close as possible to the case before it.
Could it have retrospective effect?
Yes, it can, and that's provided by subsection 12.
Yes.
Yes.
So, your argument could be that even if this does happen to be a one-off act of discrimination on religious grounds against this particular taxpayer, the solution is for the Treasury to provide an exception to cater for these specific transactions.
Yes, my lady, that's exactly right. And so, taken as a whole, the legislation is proportionate precisely because it features that safeguard. Now, obviously, there is no application to the Treasury formula, but all that means is it is open to Project Blue to bring it to the attention of the Treasury, require the Treasury to make such regulations as would deal with the problem here, and we would say, what other more perfect case can there be where the legislation would otherwise infringe a taxpayer's human rights for the Treasury to make such a disapplying regulation? My lady, unless I can assist you further, those are my questions.
Thank you very much indeed.
Would I be right, just one point if I may, but would I be right in saying that as I understand it, the discrimination is the extra amount rather than anything else, is that right?
That's right, as a result of how the 75A and B provisions operate together.
Yes, and if the taxpayer's contingency argument is correct and they can make a claim, then on that basis the discrimination disappears anyway.
And my lord, that's another very good point as to how this would apply here, because one looks at the totality of the SDLT code and how it applies in this given case. So, yes, my lord, that's another very good reason why it should be left well alone.
And I think your fifth point, which you haven't developed, is presumably this, that once the 2011 amendment is made, then that solves the problem, and you don't need to worry about the matter going forward.
Exactly right, and that is why we say that that is the most appropriate way to fix the legislation if the need arises, precisely because there will be no long-lasting effects, and that is exactly why my learned friends is so inappropriate, because there will be a lasting effect on the statute book, even though all of this problem is now behind us because the legislation is totally changed. Thank you, my lady.
Thank you. Well, we're grateful to everybody, but of course there is an outstanding matter. The cat among the pigeons, which you were delivered last week. Obviously, you need time to think about how it might or might not be in the slightest bit applicable. Please do not think that because the author of these offending words is my husband, that I agree with him. I merely wished to draw to your attention a rather powerful comment on this case, which had been published in a learned work of some authority, and to have your observations on it, and to see what, with mature reflection, obviously it is to the revenue's advantage, the point that my husband is making, so you may wish to take advantage of it or you may not. That's entirely up to you. We will have your written observations. How long would you like to... You'd better go first, had you not, and then Project Blue can respond. Sorry? We might. It's just possible.
Is it to the revenues?
Yeah, I thought of that too, yes, but I want to know.
We need to fix a timetable now anyway.
Yes, we do. That's what I'm doing, yeah.
Well, my lady, I'm informed it may take a little while to...
to revise the land law that people ought to have known in the first place.
No, I think more, my lady, to see how it fits within the policy of the Act and what has been done. So those behind me think that they would need certainly until Easter, which I think is the date 29th of March, I think is Maundy Thursday.
So that more or less gives you 4 weeks, isn't it?
That more or less gives us 4 weeks, yes, my lady.
We say 28 days, and how long would you need? Because you'd be thinking about it before you see what they've got to say.
If we said 28 days thereafter, then that takes Easter out and leaves us enough time to deal with it, I would have thought.
Now, it is just possible, of course, that all of this will be rendered completely unnecessary as a result of the conclusions that we reach on the major issues in the case. But in effect, the revenue would have to win on absolutely everything for that to be the case, I think, because otherwise... at least prima facie, this is a comprehensive answer to, well, possibly not to the wrong return problem. It's not necessarily an answer to
No,
that.
my lady, it might not be a complete answer to the. I'm just wondering how it affects the consideration issue, but certainly in relation to the sort of substantive
it probably
question.
knocks out the whole thing, because
It may knock out.
if you recall, what is said in that is that 71A is OTOs,
Yes.
because you always were a mortgage and you couldn't get out of being a mortgage.
Yes.
So you didn't need it.
Yes.
No, I think one does end up in a position, if Professor Farrand is right, that one ends up with a tax charge in relation to the original transaction
Exactly
Yes.
so.
on the 959.
Absolutely. That's what one ends up with.
Yes.
And everything else sort of is out. But the wrong return point is probably, I don't know, because that's the return you put
That's the
in.
return we put in.
Well, it would then, the argument would then, yes.
It solves absolutely
I'm not
everything.
my learned friend's case for him in any way whatsoever. But maybe we then say it's a 75A return. But
Unless you can distinguish between a non-transaction return and a transaction return about the same transaction.
the only other thing I was going to draw to your ladyship's attention was the fact that probably and technically I had a right of response to my learned friend's
Yes,
argument.
absolutely,
I think that is in relation to the case management point.
yes.
I think I can make my submissions by reference to my printed case and leave it at that. And as I see it, it's a short passage at paragraph 99 onwards on page 211.
Thank you. That's quite correct. That's quite correct.
Yeah.
Well, we'll say further written submissions due within 28 days and reply from you within 28 days, unless you are notified that they're unnecessary. But you best start working on them. Well, we thank you all for a most agreeable 2 days debating these very interesting issues. And we will now go away and see if we can work out what the answers are. Thank you.